Hey guys, so today we are talking about criminal law. Criminal law, as distinguished from civil law, is a system of laws concerned with crimes and the punishment of individuals who commit crimes. Thus, where in the civil case two parties dispute their rights, a criminal prosecution involves the government deciding whether to punish individual for either an act in omission. A crime is any act. Omission is violation of law prohibiting said action of omission. Criminal courts. Each state decides what conduct to designate a crime. As such, each state has its own criminal code. Congress has also chosen punishment curtain conduct. Codifying federal criminal law is the title of 18 of the U.S. Code. Criminal law vary significantly among the state of the federal government, while some states resemble the common law criminal codes. Other, like the New York penal law, closely mimic the Model Penal Code (MPC). Codification of criminal procedure. Congress codified the federal criminal and law criminal procedure in the title of 18 of the U.S. Code with 1 to 72.5 dealing with crimes. Title 18 designates various conduct of federal crimes such as arson, used criminal weapons, counterfeit and burglary, embezzlement, espionage, gungeonage, and kidnapping. The state usually prescribe maximized sentence appropriate for the convicted individual. For additional federal regulations, consult 28 CFR. The federal government has codified the specific procedure which must take place during a criminal proceeding in the federal rules of the criminal procedure. Elements of a crime. An individual commits of a crime in the act of the that fulfills very element of often that state establishing of the offense and establishes the elements of the offense. In a general value, crime involves three elements. First, the act of conduct occurs. Second, the individual's mental state at the time of act means rea. And the third, constitution between the act on the effect, typically either proximate constitution but for caution. In a criminal prosecution, the government has burden of the proof establish very element of the crime beyond on reasonable doubt. According to the Supreme Court in Annulus v. United States 575 U.S. 2015, when the statute does not prescribe specific mental state, a court will infer the means area which is necessary to separate wrongful from innocent conduct. Type of crimes. Crimes can be generally separated into the four categories: felonies, misdemeanors, inchoate offense, and the strict liability offense. Each state and federal government decide what of the conduct and criminalize. At common law, there were 9 major felonies: murder, robbery, manslaughter, rape, sodomy, larceny, arson, mayhem, and burglary, and various misdemeanors: assault, battery, false imprisonment, perjury, and imitation of justice. The U.S. Code of the more expansive than common law. Nonetheless, Congress has limited power to do the make criminal laws, as this power is generally reserved to the state criminal courts, such as the New York penal law, are the far more complicated than U.S. Code. The NY penal law prescribe 9 levels of felonies ranging from residential mortgage fraud in the fourth degree to the terrorism. The federal government and the state government has created various sentencing guidelines. Federal courts of the federal sentencing guidelines, while state courts will look the state specific sentencing guides. Liability of applies when multiple parties are involved in the traditional first step to the classify of the partitions according to the following categories. Principal in the first degree, those who actually commit a crime. Perpetrator, perpetrators are not accomplices, and this section does not pertain the principal in the second degree, those who aided, consult, command on the encourage the perpetrator in the actual commission of crime, and after in the considered on the accomplice. Accessory before the fact, those who has aided, consult, command of the encouraged of the perpetrator to the commit of crime without actually being present at the moment preparation. And accessory before the fact is considered at accomplice. Accessory after the fact, those who did individual knowing individual to be criminal in the effort is hinder in the individual detection, arrest, trial of punishment. Accessories after the fact is guilty of separate crime, so this section does not pertain to them. To convict the accomplice, the prosecutor needs to be established to requisite actus reus means area, that is, prosecutor must prove the accomplice act of the sport of perpetrator had to the request mental state while doing the. It is important note that judication allow accomplice to the prosecute independently of the principal predator, thus that accomplice could be found guilty of a more severe offense than principal. In certain jurisdictions, in accomplice may be convicted while the alleged perpetrator in execute.